Us now, Christopher Green, law professor at the Ole Miss Law School. Good to see you again, Professor.
Good to see you. Exciting day.
Man, it is. So let's start with the big news of the morning where the Supreme Court says that presidents are entitled, and I'm using the technical legal term here, some immunity.
Yeah.
It's kind of the way they described it.
Well,
break it down for us.
My exams always say, if I give a question, yes, no, or it depends. You can't just say it depends. You got to say what it depends on. So this is why we get the big bucks. So both the Trump and the net choice cases had it depends answers. So basically what they're doing, what the court is doing in the Trump case, they're saying, well, you got three categories. One is constitutional core things the president's allowed to do. So the president gets executive power. He gets to supervise subordinates. So, for instance, he's got these conversations with his attorney general. So Bob Barr in December 2020, Trump says, hey, can you do something about these election claims? And Barr says, that's nonsense. So Trump says, okay, well, I'm going to get myself a new attorney general. So he gets himself a new attorney general. Has some conversations with that fellow, and then he's also not playing ball. So Trump has a bunch of conversations about getting himself yet another attorney general. So those kind of conversations are part of the constitutional core of executive deliberation and the presidential supervision of subordinates. Then you have an interest. So that's one category. A second category is official acts. So those are presumptively immune unless criminalizing it would be too intrusive into what the executive branch is doing. So that overcoming the presumption part of it is super, super unclear, but also just which box these things go into. And then you have unofficial acts. So you have things like conversations with the vice president. Okay, well, what is the vice president? So the vice president, I think technically really is just a legislative officer. His only constitutional power is to preside over the Senate. So there's some discussions about what exactly the vice president, his job is, and whether the presidential conversations with the vice president are akin to conversations with the attorney general. So you might remember Hamilton musical, tell my wife that John Adams doesn't have a real job anyway, because Adams is just, his only job as vice president was to wait to see if the president is gonna disappear. And of course, after 1945, when we discover that Truman didn't even know about the bomb, we give the vice president responsibilities. Really, it's responsibilities to know stuff like the atomic bomb, so that if suddenly the president's killed or something, and the vice president has like minutes to decide whether to push a button, he's able to do that. So there's a bunch of stuff about just like specifically about vice presidential power. It's probably going to be the leading precedent about vice presidential power, as interesting as that is. Then there's a bunch of questions about like the December tweets about come to the ellipse, it'll be wild. And conversation. So the president in the debate, he mentioned, well, I talked to Nancy Pelosi and I offered her a bunch of troops, and she said she didn't want it. President's, calling down to Georgia, saying, "Hey, can you people make sure you're doing this properly?" Wink, wink. Properly would be giving me another 11,000 votes. There, the court is. Most of those seem to be private, but maybe they have some sort of official nexus akin to like Grant in 1876 sending troops down to the South to make sure that the presidential election does the right thing and approves electors who are going to vote for Rutherford Hayes. So all of that 1877. So that, in 1877, remember that controversy about electors lasts for months, and so there's some questions about whether what the president is doing with respect to the process is official or not. There, the suggestion really does seem to be there's not a federal government responsibility as such for doing it. The states are doing it. So the federal government and the president specifically doesn't have authority to tell states what to do as part of his official duties. So that seems like that stuff is likely to be in the unofficial category. And then you've got unofficial stuff like.
Let me interrupt you right there, Professor. Here's the question: like, who's the arbiter of what's official and what's unofficial?
Well, right. Okay. So, is it going to be? So the answer to that is it's going to be the court. So one thing they stressed several times is this issue has to be resolved before you can have a trial. So there were some suggestions that, we can just put a jury instruction and then just tell, so this is going to be 12 folks from D.C. Making a decision as the jury. Maybe we could just write a jury instruction that says, okay, is it official? You get to decide that. And they say, no, it's got to be the court. So it's going to be, what happens practically, it's going to be remanded to the D.C. Circuit. They might or might not add something to what the court did now, but then it's going to be sent back to the trial court, the district court for the District of Columbia, and they will try to answer all these questions that the Supreme Court has now posed. After they make a decision about that, after the trial court does that, then there will be another appeal up to the D.C. Circuit just on this question. And virtually certainly another, unless Trump gets elected again and dismisses this whole thing, and then another appeal up to the U.S. Supreme Court. So it's pretty clear. Ultimately, this decision is going to, at least to the extent that it depends on the law, is going to be by the courts. If there are factual questions about exactly when A said what to B. In theory, you could have that bit get resolved by the jury, and just bring in the testimony and most of the internal deliberations that are controversial. I think those are going to get covered by the immunity holding, but it's they would have to we have to see how it looks like when the lower courts deal with it.
In her dissenting opinion, Justice Sonia Sotomayor says, orders the Navy SEAL Team 6 to assassinate a political rival, ? Immune. Organizes a military coup to hold on to power. Immune. Takes a bribe in exchange for a pardon. Immune. So she wasn't too happy with it.
So she's really in that little bit. I think she's kind of ignoring the fact that that the court says it's only presumptively immune. Justice Alito at the oral argument had a pretty good answer to the SEAL Team 6, which is that the Uniform Code of Military Justice actually says you're required to be insubordinate in response to an illegal order. Yeah. So if you're just a low-level person in the armed forces, if you get what looks like a patently illegal order, you're supposed to disobey it. So that's not terribly much comfort. But of course, the idea that the president is going to avoid this because he's worried about getting criminally prosecuted down the road, that doesn't seem like much of a safeguard either. But it was a pretty hot dissent. There were pretty hot dissents in the other ones too. So the timing when it gets released. So here in the Central Time Zone, we're waiting at 9 a.m. And 9 a.m. we get the first case, and then when's the second case? It comes out as soon as they're done reading the summary of the opinion and the summary of the dissent from the first case. So it was like 9:15, 9:20. And then eventually we get the Moody, and then that comes out, and then once they're done reading that, then we get the Trump. And so we don't necessarily know, unless you're in the press group, exactly how long the Trump dissent took to read, but it was clearly hot enough that I think the justices, or Sotomayor at least, was interested in reading that a bit, and probably Jackson as well.
Yeah. We're up against a break right here. Can you hang around with us, Professor?
Oh, sure, lots more. There's 9 other ones to talk about.
The Chevron case in particular is one that really intrigued me as a business person. Get your thoughts on that. We're coming right back. We've got a law professor, Christopher Green, on the line with us. We're live in the Element Wealth studio. Ole Miss law professor Christopher Green. So, Professor, before we move on away from this presidential immunity case, I mean, bombshell ruling, one for the ages, just handed down a couple of hours ago. How do you see this playing out with respect to Mr. Trump's outstanding cases?
Yeah, so this particular case, they're clearly going to go back to D.C. and have some arguments about the immunity thing. One thing that's interesting, Justice Thomas had a concurrence talking about a completely different issue, Jack Smith's appointment, which has been an issue in the Florida case, the documents case. So there's a bunch of technical stuff that hadn't gotten nearly as much attention, certainly in the press. But he thinks, hey, this is a very serious issue that needs to get discussed, and the judge in Florida was definitely interested in that. So that I think Thomas's opinion there is definitely going to influence that. The Georgia one. So this is criminalizing. This is a RICO one with a gazillion defendants and all. Just super detailed set of stuff. That is going to be somewhat possibly affected because it, there's this immunity claim that now is pretty important, and there's a little more meat on the bones in terms of explaining what that is. In terms of the New York ones, it's not going to really have anything to do with it. That's just private litigation. So that's that's akin to the kind of Clinton v. Jones style claim that, because I'm president, you shouldn't be able to hassle me. I mean, there are some clearly retaliatory prosecution elements where the New York people are talking about, the prosecutors talking about going after Trump like during the campaign. And then there were some kind of campaign contribution elements to the New York case. But clearly that's acting as a candidate. So the opinion today, official acts are clearly distinguished from acts as a candidate. So because that was really just candidate focused, as nutty as it was, it's not gonna really, I think, be affected by the Trump case itself. It is subject. New York case is subject to possible Supreme Court review based on these federal campaign things, but that's just sort of because it's a federal issue, not because of the immunity as such.
Yeah. Well, how do you think this would play out as far as whether or not, let's say, the Georgia election interference case and then the federal election interference case, official business?
I mean, it certainly seems like there's some unofficial. There are clearly some. It certainly seems like there's some unofficial aspects to it. The court doesn't actually. One thing the dissent complains about most vociferously, they never actually say this particular action was purely private, so you can go after it. I think the stuff about the federal government not having a specific role in what states do means that a lot of the Georgia stuff is probably going to be able to go forward. I mean, they've got to get their act together in terms of their prosecutorial.
Long way to go on that.
And all that. Yeah, there's Georgia is like, oh my word, there's some crazy in this. But so I mean, Jack Smith, at the argument in Trump, he's like, I can, you limit it to unofficial stuff. I can roll with that. It'll excise a bunch of stuff from the indictment. There's some stuff you can't talk about, but I'm cool with that. Just give me the ruling now so I can go ahead. Yeah. But it clearly is not, the emphasis they put on immediate review. I mean, that's not gonna go forward before the election, and even I mean, it's unclear how much of a hearing you could have on the immunity issue, even before the election. But it's exciting. It's exciting stuff.
Seems more applicable to the classified documents case. It just seems like it's more in that wheelhouse than the other two, which I think could bring about lots of arguments that this was not official business. But at this point, I don't think any of them are going to proceed until after the election, if they ever do.
Yeah, I mean, there clearly will be some initial steps in the appeal in the New York State case, and he's going to have the sentencing. There is a rule in New York that at least it's just a presumption, but presumption that you get bail pending appeal. So the notion of him spending a week or an afternoon in New York jail or something as a way to improve ratings during the convention is unlikely to happen. I could imagine some people thinking, "Oh man, this would be lit." I'll leave the convention and then like head to jail for an hour or something, and then come back and say, "Look at these people, what I'm doing." But I don't. As dramatic. I think Trump is being advised by some people who are telling him to be a little less dramatic this time.
The so-called Chevron case. This was a big deal to me. What do you think?
Yeah. So we've had 10 cases since we last talked. 4 of them are clipping the sales of administrative agencies. So what Loper Bright, this case overruling the Chevron doctrine, what it essentially says is agencies are required to give reasons for the interpretations of statutes that persuade the courts. They can't merely say. So what Chevron says is if there's a gap in a statute, an agency can come in and say what it thinks it ought to mean within a zone of reasonableness. And the agencies have authority to control what the courts say. The courts might say, well, I might disagree, but you're the experts, so as long as it's within a zone of reasonableness, that's enough. So Loper Bright says, no, that's not how we do it. You can give us arguments, and you have a lot of things about you experts, that might give you power to persuade if lacking power to control. So that's this phrase from 1944, this case Skidmore. So one of the memes that I liked, there's this one with Henry Cavill as Superman, and then the guy playing Aquaman kind of sneaking up behind him. So the Superman guy was Chevron, but then the guy sneaking up behind him was Skidmore. So is Skidmore deference gonna give you similar results? The courts would have to take responsibility. So the courts in individual cases, they could say, okay, the EPA comes up with this stuff and they've got a bunch of smart people with reasons to read the statute to say X. We're good with that. The court would have to add at a retail level, we are good with that. We agree with the EPA. But assuming the EPA, as smart people who can translate their knowledge for lay people, that'll be good. Jarkissi, one of these other cases, requires agencies to use, not the agencies to use civil juries, but to go into court and use civil juries under the 7th Amendment. So I would say it's kind of similarly requiring the experts to translate what they're saying into a form that lay people or generalists, especially the courts, agree with. So the SEC really, for the claims that they have that are very similar to old style fraud claims, they can't adjudicate it themselves in house. They have to go into court, it took a long time for this to get settled because most of the defendants are like, well, this is all crazy complicated. I don't want just 12 randos who are citizens to decide this. I want the experts. But because it requires these cases to go to court, the people who are targeted by the SEC, they get to make arguments to the likes of the Fifth Circuit or just other judges. They're going to be supervising it in ways that the SEC supervising its own administrative law judges doesn't do. So I'd say that both of those are pretty big victories for the regulated community, people who want to push back on regulations. 2 other ones were pretty big too. The Quarter Post that came out today, that resists a pretty aggressive statute of limitation reading by the Fed. So basically, if an agency does something, there's some people who can challenge it right away. But what about somebody who hasn't even entered that business yet? So years later, somebody says, hey, I think this regulation that you people adopted 15 years ago is unconstitutional. They say, what the court said today is the statute of limitations only begins to run when you, the person getting regulated, actually get injured. So it's going to allow, it's not going to allow agencies to kind of lie low for a while and then say that everybody else's statute of limitations has run. The other one is the Ohio versus EPA, which they're pretty fairly aggressive about this Good Neighbor Clean Air Act thing. So the courts are more receptive to claims that the agencies have been arbitrary and capricious. So
we got to go,
bunch of
but
interesting administrative law.
Man, it's been a busy term for sure. We got to go. Always appreciate your expertise, Professor. Thanks. We'll talk to you soon.
Great to see you. Take care.
We're coming right back, folks, in the Element Wealth studio.